Okay.
It's the judges. Let's go back to the judges now, because in the prosecution of those cases, some of the judges that are being prosecuted currently have had some issues with some of these cases that had to do with diversion of petroleum product and all that. So how do we ensure that the corruption, this war against corruption, which is now back to the judiciary, is well seen to have been fought completely?
Well, with the greatest respect to the very, distinguished judges of the Court of Appeal, I want to beg to disagree with the reasoning and the conclusion of that judgment that says that the law enforcement agencies cannot prosecute the judges until the NJC takes a decision on the proof of evidence, submitted to the NJC by the law enforcement agencies. In other words, what the court said, the Court of Appeal said, is that, look, you must first of all investigate the judges, gather evidence. That evidence, you cannot use it to prosecute them. You must submit that evidence to the NJC. And the NJC will look at the proof of the evidence you have against them, discipline them, remove them from office. Then you can now go ahead and prosecute them. Now, unfortunately, that decision does not take into cognizance the provisions of the Constitution regarding the powers of the Attorney General of the Federation, and also the provision regarding immunity in the Constitution. Because even the immunity given to the governors and the president and the deputy governors and the vice president, that immunity is also not absolute. That immunity says, look, if you do something, either the House of Assembly will have to remove you too before you can be prosecuted. You have to present that evidence before the House of Assembly to impeach the governor or impeach the president, as the case may be. Then he can now be prosecuted. In other words, the judgment now puts the judges in the same realm as the president, the vice president, the governors, and the deputy governors. In other words, that they must be removed from office first before they can be prosecuted. So it gives the same class of immunity, the same type of immunity that the governors have to the judges. However, there's a doctrine called the doctrine of covering the field. The doctrine of covering the field in law is that once the Constitution has made a provision regarding a subject matter in a part of the Constitution, and it has covered that field, you cannot in any way expand the meaning again or bring in other things into that, the provisions of that Constitution, into the provisions of the Constitution. If the Constitution has covered that field. In other words, in respect of immunity of individuals, the Constitution has covered that field and has clearly stated those who can enjoy that type of immunity. The effect of that judgment is to expand it and bring judges into that class of those who can enjoy that kind of immunity. The other one is that it has also restricted the powers of the Attorney General to prosecute. Because don't forget that it's not just the EFCC prosecuting. The EFCC, the ICPC, all these prosecutorial agencies, they are all under the Attorney General of the Federation. So even when the EFCC has investigated, the Attorney General can call for the file and prosecute, because Section 174 says the Attorney General of the Federation has the powers to initiate, undertake prosecution and all that. Let me just finish. Okay. So, therefore, and in doing so, the Supreme Court has said over and over that the discretion of the Attorney General to undertake and initiate is not circumscribed by anybody at all. Nobody can circumscribe it. Therefore, if you now submit the proof of evidence to the NJC, and the NJC looks at it, and the NJC feels that the proof of evidence is not enough to remove the judge from office, and they say, well, this petition is thereby dismissed, and the judge goes back to the bench. What has happened is that, in effect, the NJC has overridden the powers of the Attorney General. That's the meaning. The NJC you have now made the discretion of the Attorney General to prosecute subject to the discretion of the NJC.
Is that permissible?
It's not permissible, because the Attorney General has complete discretion whether to undertake, initiate prosecution.
But that's also despite the Constitution giving the NJC powers to discipline its own?
Oh, yes. You see, the mistake they made is that what can amount to professional misconduct may not amount to a crime. So, yes, it may not amount to a crime. So there are two different things altogether, completely different altogether. Criminal conduct is different from professional misconduct. I'll give you an example. For example, you know, I did not support the raid of the judges' quarters without evidence. You can raid if you have intelligence reports that a crime is happening in the house of a judge. But I refuse to accept a situation where you indiscriminately raid the judges, because it appears that they raided and they were looking for evidence. That is where I disagree. But I do not say that where you cannot raid at all. You can raid if there is clear intelligence report that a crime is going on there. Now, when they raided, they saw so many things going on. You know, there were instances where they saw accounts of people, you were receiving monies from, lawyers, who were appearing before you, they had cases before you and all of that. Now, listen. And I spoke to somebody very high up there in the prosecutorial agencies. I said, look, you cannot, in criminal conduct, you must prove that these monies given to these judges were to the effect that they were to affect in respect of those cases before them. That is proved beyond reasonable doubt. So in criminal prosecution, you may not succeed